Full wave. All right, good morning still, ladies and gentlemen. All right, thank you all for coming back. Parties in the court have been working and worked both on Monday afternoon and this morning to get to the place where we are today. So what our business for today is I will read you the jury instructions. These are your instructions of law in accordance with all the other things that I've instructed you both on the first day and in between. You will be taking a copy of this back with you. So you do not have to take notes on these. They will all go back with you, and you'll be able to spend as much time as you want looking them over and discussing them. After that, you are going to hear closing statements and arguments from both sides in the case, and then we will turn the matter over to you for your decision. Jury instruction number 1. Your verdict must be based on the facts as you find them and on the law contained in all of these instructions. The issues in this case are: 1. Was defendant Ebony Parker grossly negligent? 2. Was defendant Ebony Parker's gross negligence a proximate cause of Abigail Zwerner's damages? On these issues, the plaintiff has the burden of proof. Number 3. Was plaintiff Abigail Zwerner contributorily negligent? 4. Was plaintiff Abigail Zwerner's contributory negligence a proximate cause of her damages? On these issues, the defendant has the burden of proof. 5. If plaintiff Abigail Zwerner is entitled to recover, what is the amount of her damages? On this issue, the plaintiff has the burden of proof. Your decision on these issues must be governed by the instructions that follow. In the instructions that follow, where you see reference to the plaintiff, this is in reference to plaintiff Abigail Zwerner, and where you see the reference to the defendant, this is in reference to defendant Ebony Parker. Instruction number 2. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. You may consider the appearance and manner of the witnesses on the stand, their intelligence, their opportunity for knowing the truth and for having observed the things about which they testified, their interest in the outcome of the case, their bias, and if any have been shown, their prior inconsistent statements, or whether they have knowingly testified untruthfully as to any material fact in the case. You may not arbitrarily disregard believable testimony of a witness. However, after you have considered all the evidence in the case, then you may accept or discard all or part of the testimony of a witness as you think is proper. You are entitled to use your common sense in judging any testimony. From these things and all the other circumstances in the case, you may decide which witnesses are more believable and weigh their testimony accordingly. Any fact that may be proved by direct evidence may also be proved by circumstantial evidence. That is, you may draw all reasonable conclusions from the evidence. Instruction 4. If you believe from the evidence that a witness other than a party previously made a statement inconsistent with his or her testimony at this trial, the only purpose for which you may consider the statement is for its bearing on the witness's credibility. It is not evidence that what the witness previously said is true. Instruction 5. If you believe from the evidence that a party previously made a statement inconsistent with his or her testimony at this trial, you may consider that previous statement as evidence of what the party previously said was true. Instruction 6. In considering the weight to be given the testimony of an expert witness, you should consider the basis for their opinion and the manner by which they arrived at it and the underlying facts and data upon which they relied. Instruction 7. You have heard evidence about written policies or procedures. These policies or procedures do not set the legal standard of the case. Compliance with or violation of such rules does not, by itself, prove or disprove whether any party was negligent or grossly negligent, and you must not consider this evidence for that purpose. The applicable duties and standards of care are defined in these instructions. Instruction 7.5. Plaintiff answered requests for admissions. Any manner admitted in request for admissions is conclusively established. Instruction 8. You must not consider any matter that was rejected or stricken by the court. It is not evidence and should be disregarded. Instruction 9. Any amount of damages requested is not evidence in the case. You should not consider it as evidence in reaching your verdict. Instruction 10. You must not base your verdict in any way upon sympathy, bias, guesswork, or speculation. Your verdict must be based solely on the evidence and the instructions of the court. Instruction 11. The greater weight of all the evidence is also called the preponderance of the evidence. It is that evidence which you find more persuasive when evaluated against all of the evidence that has been admitted in the case. The testimony of one witness whom you believe can be the greater weight of the evidence. Instruction 12. Negligence is the failure to use ordinary care. Ordinary care is the care a reasonable person would have used under the circumstances of this case. Instruction 13. Gross negligence is that degree of negligence which shows such indifference to others as constitutes an utter disregard of caution, amounting to a complete neglect of the safety of another person. It is such negligence as would shock fair-minded people, although it is something less than willful recklessness. Instruction 14. The degree of negligence that the plaintiff must prove by a preponderance of the evidence in this case is gross negligence, as that term is defined in the other instructions provided. Instruction 15. Several acts of negligence which separately may not amount to gross negligence, when combined, may have a cumulative effect showing a form of reckless or total disregard for another's safety. If you find the defendant committed more than one act or omission of negligence, you may find the cumulative effect of those acts or omissions equates to gross negligence. Instruction 16. A person who undertakes gratuitously or for consideration to render services to another which she should recognize as necessary for the protection of a third person is subject to liability to the third person for physical harm resulting from her failure to exercise reasonable care to protect her undertaking if A, her failure to exercise reasonable care increases the risk of such harm, or B, the harm is suffered because of reliance of the other or the third person upon the undertaking. If you find the defendant assumed a duty of care and, with gross negligence, breached that duty of care, proximately causing plaintiff's damages, then you shall find for the plaintiff, unless you find plaintiff was contributorily negligent, and plaintiff's contributory negligence is a proximate cause of her damages. Instruction 17. The defendant is not required to have anticipated or foreseen the precise injury or damages that occurred, but it is sufficient that a reasonably prudent person would have anticipated or foreseen that some injury or damages might probably result from the negligent act. Instruction 18. The plaintiff has the burden of proving by the greater weight of the evidence that the defendant was grossly negligent and that the defendant's gross negligence was a proximate cause of injuries to the plaintiff. Instruction 19. A proximate cause of an injury is a cause that, in the natural and continuous sequence, produces the injury. It is a cause without which the injury would not have occurred. Instruction 20. The fact that the plaintiff was injured does not, of itself, entitle her to recover. Instruction 21. When a defendant claims contributory negligence as a defense, she has the burden of proving by the greater weight of the evidence that the plaintiff was negligent and that this negligence was a proximate cause of the plaintiff's injuries. Contributory negligence may be shown by the defendant's evidence or by the plaintiff's evidence. Instruction 22. Contributory negligence is the failure to act as a reasonable person would have acted for her own safety under the circumstances of this case. Instruction 23. A plaintiff has a right to assume that the defendant will exercise ordinary care until she realizes, or in the exercise of ordinary care should realize, that the defendant is not going to do so. Instruction 24. If you find from the greater weight of the evidence that both plaintiff and defendant were negligent, and that their negligence proximately contributed to the incident, you may not compare negligence of the parties. Any negligence of the plaintiff, which was a proximate cause of the incident, will bar her from recovering. Instruction 25. You shall find your verdict for the plaintiff if she has proved by the greater weight of the evidence that 1. Defendant was grossly negligent, and that 2. Defendant's gross negligence was a proximate cause of the plaintiff's injury and damages. You shall find your verdict for the defendant if 1. The plaintiff failed to prove either or both of the elements above, or if 2. You find by the greater weight of the evidence that the plaintiff was contributorily negligent and that the plaintiff's contributory negligence was a proximate cause of her injury and damages. Instruction 26. If you find your verdict for the plaintiff, then in determining the damages to which she is entitled, you shall consider any of the following which you believe by the greater weight of the evidence was caused by the gross negligence of the defendant. 1. Any bodily injuries she sustained and their effect on her health according to their degree and probable duration. 2. Any physical pain and mental anguish she has suffered in the past and any that she may be reasonably expected to suffer in the future. 3. Any disfigurement or deformity or any associated humiliation or embarrassment she suffered in the past and any she may be reasonably expected to suffer in the future. And 4. Any inconvenience caused in the past and any that probably will be caused in the future. Your verdict shall be for such sum as will fully and fairly compensate the plaintiff for the damages sustained as a result of the defendant's gross negligence. Instruction 27. The burden is on the plaintiff to prove by the greater weight of the evidence each item of damage she claims and to prove that each item was caused by the defendant's gross negligence. She is not required to prove the exact amount of her damages, but she must show sufficient facts and circumstances to permit you to make a reasonable estimate of each item. If plaintiff fails to do so, then she cannot recover for that item. Instruction 28. If you find that the plaintiff had a condition before the incident that was aggravated as a result of the incident, or that pre-existing condition made the injury she received in the incident more severe or more difficult to treat, then if you find your verdict for the plaintiff, she may recover for the aggravation and for the increased severity or difficulty of treatment, but she is not entitled to recover for the pre-existing condition. Instruction 29. The plaintiff has a duty to minimize her damages. If you find that the plaintiff did not act reasonably to minimize her damages, and that as a result they increased, then she cannot recover for the amount by which they increased. 30. Plaintiff's projected life expectancy pursuant to Virginia law is an additional 53 years. You should consider this along with any other evidence relating to the health, constitution, and habits of the plaintiff in determining her life expectancy. Finally, you will be sent back with your verdict form. The verdict form has the names of the parties, the case number, and then right under it, 2 options. Option 1 says, we, the jury, on the issues joined, find in favor of plaintiff Abigail Zwerner and assess her damages at, there's a blank with the $sign, and award interest beginning on blank date. That date could be from the date of judgment or the date of the injury, or any other date that you deem appropriate. Or the second line says, we, the jury, on the issues joined, find in favor of defendant Ebony Parker and against plaintiff Abigail Zwerner. And at the bottom is a signature for your jury person. So when you go back after you have made your decision unanimously, you're going to check a box, put an X on the top line or the bottom line. If you put a X on the top line, you will fill in the amount of the award, and then any interest, the date that interest runs from, or an X on the line next to line 2, and your jury person needs to sign by both name and number. Mr. Benyazin, are you prepared with your closing statement?
Changes everything. At least it should. Now, on January 6th, 2023, a gun walked on the campus of Richneck Elementary School. That gun changed the thoughts of every student who saw it, heard about it, staff member.
Your Honor, objection.
Your objection.
It's not about the students.
Over. May proceed.
It changed what they did, where they went, and it changed one young woman's life forever. Except it didn't change the actions of one person. It didn't change where Dr. Parker went. It didn't change what she did. And those choices that she made to treat January 6, 2023 like any other day, even though a gun should change everything, is why we're here today. We're here today to ask you to do something that we can't do alone. And the thing that we cannot do alone is that we cannot achieve accountability by ourselves. That's what jurors are for. That's what you all are here to do if you find that accountability should be had. And you all may have different jobs when you walk outside of this courtroom. You may have different obligations in your personal life, but when you're in this courtroom and you walk back to that deliberation room, if you're one of the jurors that decides this case, your job is to deliberate together and return a unanimous verdict. And in doing that, one of the first things you all will do, if the judge hasn't already told you, is you're going to pick a foreperson. And that foreperson's responsibility is to make sure that everyone participates in the verdict, that everybody's voice is heard in that room, that everybody chimes in and shares their ideas and talks about the evidence. And the reason for that is that the 9 of you who are here and the 7 of you who will decide this case are here as representatives of this community to voice their conscience of what's right. Just like yesterday was election day and we all cast our ballots, you all are here individually, but as part of this community to decide what should have happened on January 6, 2023. And when you're in that room and you're deciding these issues, there may be times where you disagree. And the hard part of this is you've been here for a week and a half and you get to know each other, and sometimes we can hear you laughing as you come out, which is great. And you've made friends. But when you get back into that jury deliberation room and you're talking about the issues in this case, and you're talking about how to decide something, you're going to have to speak and share your thoughts. And we're asking you to fight. We're asking you, when you get back there, to fight for what you believe is the right outcome in this case. And when you're doing that, one of the instructions that I will point you to, and the judge talked about it and I talked about it earlier when we picked the jury, is the burden of proof. We talked in voir dire, if you remember, we said this isn't a criminal case where you decide things beyond a reasonable doubt, and I may have done this with my hands depending on which group you were in. I say this is a case you decide on the preponderance of the evidence. And I show you this because when you get into that deliberation room and you're fighting about issues or you're trying to decide something, and look, I hope you get back there and everybody takes a straw poll and says, you're with us. I hope it. And we've put on enough evidence, I think, that that may be true. But as you're deciding those issues, this is where you come to. This question of what's more likely true than not true. That's the burden of proof in this case. And so with that, I'm going to take a step back and I'm going to give you a roadmap for what we'll talk about. This is called summation. It's my chance to tell you all what I think the evidence was, but you all were paying attention. You all took copious notes. And candidly, if the judge lets you, I'm sure you could come up here and give closing arguments yourself and tell us what this case was about. I think you know it that well. So my goal here isn't just to tell you what you heard from that witness stand or what you saw on that TV. My job here is to try and talk ideas so that when you get into that room and you're having those discussions, you have an idea of, okay, how do we resolve this? What are tactics that we can think through and process, and how do we answer these questions? And some you may like, and some you may not, and that's okay. That's my job so that I can help you do your job in that room in however long it takes us to get there. So what I'm going to do is I'm going to move pretty quick. We've already talked about your job. I'm going to move quick through the second stop, which is what I'll call fault, and we're going to focus on what Dr. Parker's job was. Then I'm going to talk about the blame game. And then if you'll let me, I'm going to slow down, and I'll talk about costs and consequences at the end. And the reason I slow down is that it sounds like we're going to go fast, and we're going to try and go fast through the first part, but I don't want to lose grasp of what we're really here for. And that's to talk about the effect that this has had on this one. Sound good? All right, if we can go to the PowerPoint. So, your roadmap: fault, blame, and cost. Fault. Her job is safety. Dr. Parker's job is safety. We talked in opening statement about promises. Do you remember that when Ms. Toscano came up here and we talked about expressed and implied promises, the things we say and the things that are meant with what we say? And when we get out onto the road, I know a lot of us don't have keys with keys anymore, but there's still keys out there. I have a 4Runner. You put that key in the ignition, you turn, and as you go out onto the roadway, you're making a promise. You don't have to say it to people, but what you're saying is, by strapping your seatbelt and going out onto the highway, you're saying, I promise to look out for you. I promise to see the stop signs that are there to be seen. I promise to stop at those stop signs. I promise to turn my blinker on when I go to change lanes. I make these promises because you rely on me to make the promise, and I rely on you to make the promise so each of us can go home at night and see our families. We make those promises even though we never say them out loud. And then there are promises that come with what we say, or how we say them. There are promises when you answer the phone and agree to take action or to find something out. And then the question becomes, what happens when you put the phone receiver down on the table and you don't meet that promise? That is what the judge was talking about when he instructed you on what's called Instruction 16. And this is the law to govern you in this case. It says a person who undertakes gratuitously or for consideration, in other words, whether you're paid for it or not, to render services which she should recognize as necessary for the protection of the third person, is subject to liability, talking about fault, to the third person, in this case, we're talking about Ms. Zwerner, for the physical harm resulting from her, Dr. Parker, failure to exercise care to protect her undertaking. So what does that mean? And we'll get through some of this evidence in a moment. But whether it was on a phone or through a doorway, around noon on January 6, 2023, there was a communication. And that communication involved a gun and a backpack. And she answered the call. And the question that you have to decide now is, by answering that call, by making the promise that I'm going to find something out, explicitly or implicitly, we can talk about other promises later, did her failure to exercise reasonable care, in this case, did her failure to act, to do something, increase the risk of harm to Ms. Zwerner? Or, it's an or question, not an and, did Ms. Zwerner suffer harm because she relied on the third person? That is, she relied on somebody to act. That's our framework, right? That's what we're talking about in this case. That's the law that governs your decision. And let's talk about facts as they come through them. You're going to hear, before I do that, I have to explain this thing of negligence that we talked about. We've heard this word negligence. We've heard the judge talk about gross negligence. We'll look at the instruction a little bit later. Best way, I know how to explain it, okay? Hang with me. If I had a baseball and I turned around, sorry, Keith, Mr. Williamson, if I turned around and I thought, I'm going to try and hit that gavel off the top. Actually, I'm going to change my mind. I'm just going to point right at Mr. Williamson's forehead. And I threw that ball, meaning to hit his forehead. That's what we call an intentional harm, right? You get it? I meant to do it, and I did it if I threw the ball. Negligence is knowing I'm not as good a baseball player as probably the judge. If I looked up at that gavel and said, or maybe that apple, said, I can probably hit that. And I threw it and I hit Mr. Williamson. I didn't mean to do it. I didn't intend to hit him. But it was not the wisest choice. Opposing counsel said at one point in the opening statement, it was inadequacy. Remember that line? It's not indifference, it's inadequacy. We'll come back to that. It's not quite what I should do. Gross negligence. If I turn around, sorry y'all, and I decide I'm going to try and throw the ball to Mr. Bright. And in between Mr. Bright are Miss Zwerner and Miss Toscano. The risk of danger has gone up, right? It's going to be harder for me to throw that ball. And the truth is, I ain't that good at baseball. And so there's just as good of a chance that I throw it at him or I hit one of these two. That means I'm kind of indifferent. I may get it done, I may not. That's what we call gross negligence. The risk of harm has increased, and I'm somewhat indifferent to the outcome. And then we talk about recklessness, which is in one of the instructions. Recklessness is saying, I'm going to try and hit that back wall through that crowd of people, and by golly, I hope I do it, knowing the likely outcome. So we have levels to this, if you want to think of it that way. And the question is, how great is the danger? How great is the harm, the risk of it? And when I act or fail to act, how likely is it that something's going to happen? So, we've seen a lot of faces. We've heard a lot of testimony. I told you I'm not going to go through everything, but let's go through this. I told you at noon or around noon that day, there was Miss Kovac was told that by two girls that there was a gun. What we know is that Miss Kovac shared that information with Dr. Parker. And what I'm going to come back to throughout this closing argument, throughout the summation, is that every minute matters. Every minute matters. Ms. Kovac says, we think the gun's in the backpack. And according to our expert, Ms. Shufflebarger, as you remember, at that moment, a gun changes everything. A gun changes everything. You stop and you investigate. You get to the bottom of it. You get to the bottom of that backpack. You get to the bottom of his pockets. Whatever it is, you get to the bottom of it to know whether that gun is real and on campus so you can deal with it. But that's not what happened. So later a communication comes back. We think it's put in the pocket. And then the check of the backpack happens, and it's gun out of backpack. And this is where we have the line, there are little pockets. It's a line that we heard on the stand. It's a line that you just can't forget when you hear those words. And then you have search the person, and the response is check the bag. And I want to stop here. By this point in the day, Miss West has asked Mr. Sims to ask Dr. Parker, have you searched the person? And when that communication is read or brought to Dr. Parker, what do we know? We heard in the instructions that evidence can be proven by direct and circumstantial evidence. What does that mean? I don't need to see the rain coming down from the sky to know it's raining if I walk out in the morning and there are puddles on the floor, right? I don't need to see the rain. I know it rained. And when Dr. Parker says, in response to, did you search the person? We checked the bag. What that tells us is that that was a real threat. That it was accepted as true, so much so that we needed to check the bag. All this talk about we didn't think it was a real threat. It wasn't a credible threat. Why are you agreeing with Ms. Kovac to search the bag if you don't think it's real? And when they say, did you search the person, and the response is, we already checked the bag, guess what that tells us? We thought it was real, and we don't know where it is anymore. We don't know where it is anymore. And then the boy outside of Miss West's classroom crying, remember? Crying, not wanting to go back into Mrs. Z's classroom where he's supposed to be. Says bullets and shoot. The boy showed me bullets, JT showed me bullets, and he said if I told anybody, I would shoot. Bullets, shoot, gun. The only way you can shoot a bullet is if you have a gun. And to tell us that telling a boy that he will be shot is not a threat, not a threat, goes against the very language that 6-year-old used. And then he goes and has a conversation with her again. You heard from Miss West, who said he was crying scared. I talked about R a moment ago. He was crying scared. And I suspect what you're going to hear from the other side is, well, we didn't get good information. Remember that from Dr. Klinger? Well, we didn't get good information. We didn't know that he was crying and scared. Somebody should have told Dr. Parker that he was crying and scared. When we go out onto the road and there's a stop sign on the corner of the street, tuck it behind a little corner or right there for us to see either way. It's our job as we're driving down the road to see the stop sign. It's our job to look out for the stop sign. It's our job to find the rules of the road and the signs of the road so that we can then govern our behavior. It was Dr. Parker's job to investigate. The manual that governed their relationships amongst each other told her that you must first assume it is credible unless analysis suggests differently. Cause the student making the threat, if known and on campus, to be immediately removed, pending further investigation. What does that mean? That means you can't stick your head in the sand. You cannot stick your head in the sand and then come into court and say, I didn't have the information, when it was your job to find it. When it was your job to look for it and to do the investigation and to talk to that little boy who saw the gun and to talk to those 2 little girls who talked about the gun and to talk to all of these people. If it's your job to investigate, which their handbook tells them it was, you can't come into court and say, I'm going to close my ears, close my eyes, put my head on my desk, and then use that as a defense to my case. The law says you know it because it was there to be known, because the stop sign was on the corner of the street and it should have been seen. It's no excuse to walk into court on a traffic ticket and say, well, Judge, I didn't see the stop sign. The stop sign was there. The stop sign was there. Feet, yards from her. And then, in my view, you turn up the dial. Because at this point in the afternoon, there is a accumulation of information. We saw a gun. It was supposed to be in a backpack. We don't know where it is. It might be in his pocket. It was shown to a boy at recess with bullets. We still don't know where it is. He's crying, won't go to class. And another request. Can we search the person? And I suspect they'll come up here and they'll say, well, Mr. Rawls told you that he didn't think it was credible. My response to that is let's look at actions, because our actions speak louder than our words. Did we hear any other evidence of Mr. Rawls coming and asking to search just kids at random when he didn't think there was a threat? We talked, and all of the evidence is that searching, and even Dr. Klinger told us, searching a child is something that you do delicately. You only do if it's necessary. That's what they're taught. And he came to her directly and said, have we searched the boy? Again. And he wasn't the only one in that moment. Because in that moment, when she heard, West heard, that they had not searched the person, Mr. Sims goes and stands outside the door of Mr. Rawls and Dr. Parker and says, are we searching the person? That's 3 times somebody is asking her to do this. 3 times. Countless times where we're talking about the boy throughout the day and a gun and where it is, but 3 times to search the boy. That should be flashing at you to act. And the response? Let's hold off. Let's hold off. It's 1:40 in the afternoon. Mom's going to be here at 2:30 p.m. to pick him up. Let's hold off. I told you that I would talk more about promises, right? When Mr. Rawls walks down the hall, being told directly, let's hold off and wait for Mom to come and then we'll take the action. What does that tell us? Like the rain that we did not see. It tells us that she still thinks there's a gun. If she doesn't think there's a gun, what are you holding off for? If you don't think there's a gun, you don't say, we'll wait for Mom to come and we'll do the search. You say, there's no gun. Let me go back to my testing. It's that creeping thought, that knowledge that there is still a gun on campus that leads to somebody saying, we probably still need to do something, but let's hold off. Every minute matters. Every minute matters. And they'll say, no, that's not what she thought. That's not what she knew, right? We had a time with Dr. Klinger, weapon, firearm. We'll talk about that in a second. The very first witness in this case, and it's sometimes hard to forget because it's a week ago, the very first witness in this case interviewed Dr. Parker within days, in January of 2023, of this incident. And Dr. Parker herself said the students reported a gun in a backpack. Don't take my word for it. Take hers. At 12:20. And that at 1:40, there were still concerns of a weapon on campus. Her words to the school system as part of the investigation. Not my words. That means for an hour and 20 minutes, and we still got another 20 before Ms. Zwerner shot. There is a gun on campus. And they come up here with Dr. Klinger and say, well, she needs more information. What more do you need? You knew who. You knew what. You knew when. You knew where he was all day. You knew when he was in the classroom. You knew when he was on the playground. You knew when he was back in the classroom. What more do you need to act when a gun changes everything? And this is no time to play name games. This is no time for, well, maybe the child said bullets. Is bullets really a gun? Ladies and gentlemen, if you have an elementary school, 6-year-old, if we looked at the classroom walls, we're still teaching them how to use punctuation correctly and what words to use and how to capitalize letters. And you're going to wait until a boy says, no, it was a gun, it was a real gun, it was black, it had bullets in the gun? No, ma'am. Gun, bullet, weapon, firearm, we don't need to talk about what all they mean. Each of them required a response. Each of them. But what we know for certain is that it was a gun from her herself. And they're going to come up here and tell you hindsight 2020. Remember that? Hindsight 2020. It's easy to see now that there was a shooting, that we look backwards and now that we know there was a shooting. It's easy to know that looking at our rearview mirror. You don't need to look in the rearview mirror. There were road signs in front of Dr. Parker for an hour and a half, screaming at her, flashing at her, telling her exactly what was going to happen if she did not act. You do not need to look in the rearview mirror to know what's coming ahead. And the only reason it's in her rearview mirror is that she blew past the signs. She blew past the signs. Do we need every letter to know what it means? Do we need every letter? They're going to tell you this wasn't foreseeable. Remember that discussion? Wasn't foreseeable that this would happen. And that's why we talked about this question of foreseeability. And I'll show you an instruction on this. This is instruction 17. The defendant is not required to have anticipated or foreseen the precise injury, but it is sufficient that a reasonably prudent person would have anticipated or foreseen that some injury or damages might probably result from the negligent act. What does that mean? What that means is, and what they're going to try and argue to you is, who could have seen that a 6-year-old would pull out a gun from his pocket, point it at a teacher, and shoot. That's not the question. The question is for every moment, every minute, every second that a gun is in the possession of a 6-year-old who, I agree, has totally unpredictable behavior. If anybody has dealt with 6-year-olds, it's totally unpredictable. All the more reason to find the gun. All the more reason. That gun could have been popping up and down in his jacket and gone off. Handed it to a friend and gone off. Showed it to a friend and a book hit it and gone off. Dropped on the floor and gone off. You do not have to foresee the precise injury that was caused. Only that some injury or damages might probably result. We can go to the... And for 2.5 hours, this thing was beeping on her radar. Beeping. I use this as a metaphor to talk about what we just talked about. Because the focus here is a gun in a 6-year-old's hand. But I want you to think for a moment. Imagine there was a gun sitting right here on the playground at an elementary school. And a student comes up and says, there's a gun on the playground. Isn't the danger apparent just with a gun near the proximity of any of these agreeably unpredictable children? Isn't that the danger? Because the gun is what changes everything. And you may hear, well, we don't know if it was a real gun. We don't know. I think we heard from Dr. Klinger. Maybe it's kids talk about squirt guns all the time. We really going to take that chance? Really going to take that chance? I have friends that like to play roulette. When they go up to the roulette table and they throw that ball and they put their chips on whatever color they want, you know what they've already decided? Win, lose, or draw, I'm indifferent. That money's gone. If I win, great, I'll have a great night. If I lose, I've already accepted the fact that I've lost. They are indifferent to the chips on the table. They are indifferent to the odds that are before them. And if you're willing to gamble on a real gun or a squirt gun at an elementary school, you are indifferent to what happens next. You're going to hear from the other side. I'll point this out to you in an instruction. This question of gross negligence. It's instruction 13. The degree of negligence which shows indifference to others that constitutes an utter disregard of caution amounting to a complete neglect of safety of another person. Indifference. And the other thing that you'll find in your instructions, and I'll point this out to you to say, a gun changes everything. I've said it many times. I'll say it again. That first time, that first moment, not acting is indifference. Every minute is indifference. But even if it was just me trying to hit the apple instead of me trying to throw the ball at Jeffrey, even if it was not indifferent the first time, you follow? Even if the first time wasn't indifferent, what the law says is if I keep trying to throw the ball and hit Mr. Williamson, and every act of that attempt is its own negligence, those add up. And you start to wonder, what are you thinking? Why do you keep trying to throw the ball and you're not getting the outcome that you're trying to achieve? And so each minute, I said every minute matters, because each minute in which there's nothing done, in which the actions that she's supposed to take are not taken, in which she's not ensuring the safety of the people on that campus, each minute adds up. It adds up, even if each one of them on their own is an indifference. Go to the PowerPoint. Care is a verb. Care is a verb. What do I mean? It means that when you hear from the other side that she did something. She cared enough to acknowledge that there would be a search. She cared enough to say, well, we'll have a plan to search the boy when the mom gets here. That those acts of caring, those feelings of caring, are enough. The response is, care in the law is not a feeling. Care in the law is a verb. It's an action. And the question is, what actions did she take in an effort to meet her obligation? Part 2, blame game. We'll go quick. This is the defense. Mistakes were made, but none by me. All right, let's point the finger at all of these other people and say that they did the wrong thing. And I told you guys in voir dire, if many of you might remember, I said, look, at the end of this case isn't about the parents. This case isn't about other people. The question's just going to be whether she was grossly negligent or not. And that doesn't deter them. They're pointing the finger at everyone that they can point the finger at to try and deflect responsibility and play the name game. And the issue with that is that each of those people that they're trying to point the finger at had a piece of the puzzle on January 6th. They all had an element of it, whether it was the backpack or whether it was the bullets or whether it was the shoot or whether it was the search. Each had a piece of the puzzle. But you know who had the entire puzzle? Dr. Parker. Dr. Parker. And what they're doing is that they're telling you that, well, these individuals should have investigated. Ms. Kovac should have investigated. Ms. Zwerner should have pulled the kid out of class. Ms. West should have done something else at the parking lot. What the policies tell us in their agreements with each other in terms of how they're going to operate at the school is that those were all her job. And so what they're saying is Dr. Parker dropped the ball and they want somebody else to pick it up for her and do it. That's not right. And every time they come up here and say that XYZ person should have done something different, that Ms. Kovac or maybe Mr. Rawls should have searched, just tilt that rearview mirror and look at it yourself. Because every finger that's pointed at somebody else by the other side of this case should really be a finger pointed at themselves in the mirror. What their job was, these staff members, was to be watchmen and to sound the alarm, and it was the job of administration within each of these policies to answer the call and to come and to do something about it. And each of them sounded the alarm. And they waited on the cavalry. And no one came. I told you I'd tell you about that moment where he said, hold on. Remember the moment Mr. Rawls says to Abby, hang tight. Hang tight, we're coming. Every minute matters. And what Mrs. Zwerner should have seen coming through that door was the help that was promised to her. That we're coming. The cavalry is on the way. The first time Ms. Zwerner saw a police officer on January 6, 2023, should have been when they walked through that door, not when she was laying on her back in the administrator's office. Told you I'd pause. Pause. I don't want to rush through this. I'm going to try and be efficient, but I don't want to rush through this because it's so important. Costs and consequences. This is the part that we talked about in voir dire, and I said, how do we come to this number? How do we come to an amount of money? How is that done? And to some of you, I said, we'll go through it. I'll give you tools or I'll give you ideas, and we'll talk about the law, and we'll get you there. We'll make sure you understand what your job is and how to do it. And so with your permission, I'll start with a statement that I hope, I suspect, everyone agrees to. Everyone in this courtroom. Everyone in this courtroom. There is no material item, possession, object on this earth that is worth more than a human life. Not a single one. You're not supposed to watch the news, according to the judge. You can still watch the news. And last night I was watching the news, and I saw the news of a plane that crashed outside of Louisville, Kentucky. A UPS plane. And you know the first question that the newscaster asked? How many lives were lost? He didn't ask, well, how much the plane cost? Or was it holding freight? Or what was the freight? Or what was in the plane? First question, and the first question that each of us thinks, whether it's in our gut, in our head, or out our mouth, is how many lives or loss. And that's because there isn't a single thing on this planet that is worth more than a human life. So we start there. And then the question is, how do we count the value of a human life? Well, over time, we've come up with phrases that we use every day. We use phrases like time is money. Heard that one? Time is money. We hear phrases that started in the 1600s and the 1700s that say, can I have a penny for your thoughts? Or, is it worth my time? All of these questions tell us that we understand that there is a value, a dollar sign, as weird as it seems to think about it, that we equate to our human experience that we count in minutes, hours, days, weeks, months, years. And you heard it in this courtroom. We had experts take the stand, and they were asked, how much are you being paid for your time? Remember that? $500 an hour to be here. Now, Dr. Klinger took the stand for about 2.5 hours, more than $1,000, sitting in this courtroom, talking about life experiences that she lived. And nobody blinked an eye. We understand, whether we ever think about it or not, that there is an equation, that we can equate human life and our experiences to dollars and cents. And it's my job to try and talk to you about that, and it's ultimately your job to decide how much it's worth. So, the jury instructions will tell you what I call what buckets or elements of damages to think about. And when I say that, I mean these 4 things right here. And we'll take them in order, and I'll tell you that I'm going to merge some of them. So we're first going to talk about bodily injuries, disfigurement, and deformity. The law says that if she is entitled to recover, that is, if Ms. Zwerner has proven her case, that she's entitled to recover money for each of these elements. So why did we put on the evidence? Why did we, if we can go back, put on the evidence of these 3 doctors and other doctors that came before you? It's to show you the injuries. To show you the injuries so that you could understand, based on the jury instruction, how bad, how severe, and duration, which is what the jury instruction says. How long will this be? And this is what we talked about. That a bullet pierced through her hand, into her rib, through her lung, and that it pooled. Remember that from Dr. Munn? That it pooled and it collapsed her lung, but that cavity is still in her body. And because that cavity is there and that bruising comes through, we talked about scar tissue. Like you pull a muscle and it never goes back to the way it's supposed to be. And it stays that way, and it affects the way that they can breathe. And it pierced through her hand. We had pictures of the fragments that were through the wrist. And we talked about the issues with the thumb and the index finger and the middle finger. And you heard Dr. Anderson tell you that this is the type of injury we see in war. That it's devastating. And that even though the bullet made its way through the hand and into her body, it still rests there today. And it still rests there today because it is 2 centimeters. 2 centimeters from her aorta. She was 2 centimeters from death. And that's never going to change. It's never going to change. It's there forever, and we talked about the surgeries that were done, and even to this day, she sits here with a piece of metal on her finger. Not because she did anything wrong, but because this bone still will not heal. And I will tell you, whether that bone heals or does not heal, we know for certain her wounds, all of them, will never go away. Don't we know that? Don't we know that even every moment she goes into the doctor's office and has concerns about what her medical condition might be, and she has to tell them, I've got a piece of metal 2 centimeters from my aorta, I can't have that test. I can't do that thing that I might need. And so when we talk about bodily injuries and their severity and their duration, what we're talking about is how bad is it in the way that it affects somebody's life every day. And if you can't open a chip bag, and somebody might say on the other side, it's just a hand. It's just a hand. Is it? Is it when you return home from surgery in the hospital and you're with your mother, and we're talking about disfigurement and deformity, and you can't move your hand, and you can't bathe yourself at 25 years old? You can't use the restroom by yourself. Are we just talking about a hand? Or are we talking about what it is to have dignity and be a human being? The element of instruction talks about mental anguish. It talks about physical pain and mental anguish. But I'll tell you right now, physical pain she felt more than anyone could ever imagine. I promise you that. And we showed you videos to try and tell you and show you exactly what it was like. But even when the pain goes away or goes down, this doesn't. This keeps going. And we heard from Dr. Watson, and we spent time talking about re-experiencing. Do you remember that? And I had a roadmap stop with Dr. Watson that said brain and body. Remember that? Brain and body. Why did we talk about brain and body? Because you don't injure part of a human being. You don't just injure a hand or an arm. You injure all of them. You change all of them. And what we heard about and what we talked about is a young woman at 25 years old, who had chosen her way of life, who had decided who she wanted to be, where she wanted to go, and the purpose that she would achieve. You heard from her sister that said she had a purpose. She knew what she wanted, and she was chasing it at 25 years old. And some may say, do you want to be a teacher? Really? That's what she wanted. Maybe it's because her mother did it. Maybe it's because she wanted it for herself. But that was her choice. And they'll talk to you about cosmetology school, like she had considered this beforehand. Really? Really? She chose to be a teacher knowing full well from the experiences of her mother exactly what it meant. That it meant sitting with a printer next to you while you sat next to your sister and she watched movies. That it meant late nights. That it meant early morning. That it meant difficult times with your students. That it meant being around them and shaping the future of our country. And I'm not saying that to you to tell you that being the teacher is the most valuable thing in the world. What I'm telling you is that it was her choice. It was her choice, and her choice to be what she wanted to be is changed and taken from her. What do we value that at? What do you value it at when you decide that this is who you're going to be in life? And through no fault of your own, against your will, and without your consent, that's taken from you. That dimming of a light of a young woman who used to pop at you with color. That numbing of life's experiences. Numbing of it. What is that? That's not every couple months. I told you I would repeat this. Every minute matters. Every minute matters. When you change a human being, when you change who they are, and you rob them from the control to decide who they will be in the future, you've changed them forever. You've transformed that person. And the Abigail Zwerner that sits here in front of us today, on this day, November 5th, 2025, is not the same Abigail Zwerner that walked into the classroom on January 6th, 2023. Does anybody have a doubt of that? It's not the same person. I'm not saying it's no one anymore. I'm not saying she's any less of who she was. What I'm telling you is that she's been changed and she didn't want to be changed. And what damages do you arrive at? What number do you arrive at for somebody who didn't want this and it's been inserted into her life like a bullet fragment against her spine? Every minute matters. I showed you the video of her laying. You know the video I'm talking about, right? Outside the office. I don't need to show you again, right? I don't need to show you again as she laid in the office and the color that her sister talked about in her face and the light that was in her life, you could see was sucked out of her in that moment. And I asked her to step out of this room when we showed that video. I asked her to step out of the room because she doesn't need to see the video to know what that was like. That was her life. She lived it. And just like it might be burned in your memories, do you think it's not burned in hers? And when you think about moments of compensation, what is fair? The question that I ask you to determine is if in that moment, and if in that moment someone came to Ms. Zwerner and said, Abby, this is what you're about to experience. This is what we're going to put you through. There's going to be a boy's face you'll never forget. It's going to come to you when you don't want it to. And you're going to be walking down a hall, and you're going to be thinking you're on your way to heaven. And then for a moment, you're going to think you're not going there. Until you're shocked back to life with the pain and pressure of a colleague trying to save your life. If I stopped this case right there, if we stopped it in that moment in time, at 1:59 in the afternoon on January 6th, do you think that Abigail Zwerner would trade any amount of money and say, yeah, I'll go ahead and experience that? That moment that I thought I was not going to heaven, that my faith had failed me, I'll trade that for $10 million? Do you think she would trade it? She wouldn't. She wouldn't for a moment, but your job is the difficult one, which is to say how much would be fair in full if she had to take a trade. If a trade was forced upon her, what would be the fair amount of money? Because that's what's happened. It was forced upon her, and you have to decide how much would be close. And not just for that moment, but for the next, and the next, and the next. And the moments where she wakes up in the middle of the night, thinking of that exact moment, reliving it again, like it's playing on the screen in front of you and she doesn't need to see it. What is that worth? There are some holes. I told Ms. Toscano not to get too close to me, but it reminded me of something. We've all had that moment where you're getting a cold. You can feel it coming on, right? You can feel the tickle in your throat. And it's coming to you, and you're thinking, tomorrow, probably not going to feel too good. My nose is going to start to run. Next day, I may have a cough. I'm going to stay away from people. Next day, I'm going to feel worse. My head's going to hurt. But what we have when we have those colds is that we know that one day will come, whether it's tomorrow, the next, or next week, that we're going to throw our legs off of our bed. We're going to sit at the end of it. And you're going to go, it's gone. I don't have it anymore. It's not with me. She will never have that moment. As much as she wishes to escape in her dreams and escape in real life, every time she throws her legs off the bed, that will be with her forever. And every time she sees somebody reach their hands in their pockets, which I've tried to be conscious of, will be picking a scab at a wound that will never heal. It is for all these reasons, and for all of these moments, that when you sat here a week ago, I asked you that we would be asking you for a verdict for $40 million. And if the evidence supported it, could you return the verdict? It is because she will never be the same. And somebody might say, they might say, that's a lot of money. It is a lot of money. I agree. But do you think, for a moment, she would trade it for what she's endured? If we could tell Abby to walk out that door right now, and her sister could look in her eyes and talk to her again, do you think she would trade? This is the final thing I'm going to talk to you about. When you get back into that deliberation room, I want you to remember our conversation in jury selection, and I asked you about rendering a verdict based upon sympathy or not. Remember that conversation? And I said to you, it's not supposed to be based on sympathy for her, but it's also not supposed to be based on sympathy for Dr. Parker. Because when you go through this calculation and you decide what all of these harms and these losses and what's been taken from her is worth, it's not up to you to decide where the money comes from. It's up to you to decide what it's worth. What it's worth. And if you get back into that deliberation room and there's a conversation and somebody says, well, what effect will that have on Dr. Parker? Or how will she ever be able to pay it? And if for those reasons you reduced your verdict, the number might be correct. Whatever number it is that you decide in that moment might be correct. But it would be the right verdict for the wrong reasons. Because the only reason that you can reduce the amount of what it's worth to her is if you decide it's not worth as much as what we're asking. And that's a critical point, because at the end of the day, what we want is a right verdict, but we want it for the right reasons. Because if it's full justice. Whatever full means to you, whatever you decide full is, that is full justice. And any centimeter or sip less than full justice is injustice. And injustice anywhere is a threat to justice everywhere. And so when you decide this case, when you analyze the facts, when you consider all the evidence, and you decide what's full and what's fair, I'm asking you, and I trust you, to render the right verdict for the right reasons. Thank you so much for your attention.
All right, thank you, Mr. Beniosen. All right, I think based on the timing, it's probably appropriate to take a lunch break now, because you wanted a break to set up anyways,
Yeah,
correct?
I can take a short break and go ahead now, or I can wait till
I think because it's 1 o'clock, we'll go ahead and take our lunch break. Now we'll keep it to 45 minutes, so no one has to go anywhere. We will come back at 1:45 for the defense's closing and then my final instructions to you. Please do not discuss the case yet. It is not time for you to do so. All right? All right, thank you. Let me take the jury out for lunch.
Good afternoon. I'd like to begin by acknowledging the last 6 days you've spent paying attention to the evidence in this case. It's vital to our judicial system, and I want to thank you for that. I'm going to tell you what I'm not going to do today. I'm not going to talk about verbs. I'm not going to talk about puzzles. I'm not going to talk about rain. I'm not going to talk about plane crashes. I'm not going to talk about baseball. And I'm not going to talk about a Wheel of Fortune sign that has 2 tickets to paradise on it. I'm going to talk to you about the evidence that you've heard in this case. We're going to start here. You'll receive a jury instruction that says that you can't base your verdict on sympathy. And why do I say that? Because who here doesn't feel sympathy for Ms. Zwerner? No one. No one. We're not here to challenge that. But what this case is about, it's about real-time judgments in an elementary school on January 6, 2023. Real-time judgments, not hindsight judgments. It's about the likelihood that a 6-year-old little boy had access to a firearm, access to bullets, dropped off by his mom with a loaded firearm in his backpack, took a loaded firearm out of his backpack, aimed a loaded firearm at his teacher, pulled the trigger, and shot the teacher. It was unforeseeable, it was unthinkable, and it was unprecedented. You heard many people tell you that, but we're going to start with this person. Who was that? Amy Klinger. She's a national school safety expert. She's written a book on school safety. And she came here and she told you the framework about how decisions are made among administrators and people in school systems, and we'll get to that later. But she told you, Mr. Beniosen talked about me blaming everyone else, but she told you that everyone involved was doing an analysis that day, but they did not perceive this to be a plausible imminent threat because it was a 6-year-old. It was unthinkable and certainly unprecedented. But now we're here. We're in the hindsight phase. Criticisms to find fault. 3 years later, with the outcome known, trenches have been dug. Somebody's got to go down. We're going to blame this person for it, Dr. Ebony Parker. She was the assistant principal at Richneck Elementary School on January 6, 2023. We'll talk about the issues in the trial, and I'm going to move past this quickly because Your Honor is giving you jury instructions. You're going to take the jury instructions back, and you'll see all the issues in this case. And I won't belabor this issue, but I'm going to tell you something. When you get back there, I want you to look at jury instruction number 16 about assuming a duty. And you're going to find, when you read that instruction and you apply it to the evidence in this case, that Dr. Parker did not have a legal duty to protect Ms. Zwerner. She did not volunteer to protect Ms. Zwerner. You'll remember the admissions in the case that we read to you? These were Ms. Zwerner's admissions. She admitted that on January 6th, before the shooting occurred, she did not receive any communication from the defendant expressly promising or agreeing to protect her from risk of harm by JT. She admitted that before the shooting on January 6, 2023, she did not communicate to Dr. Parker that there was reason to believe that JT might possess a firearm. She admitted that on January 6, 2023, the only time she communicated directly with the defendant before the shooting was when she went to defendant's office and told her about JT's behavior during lunch. And she admitted that on January 6, 2023, before the shooting occurred, she did not receive any communication directly from Dr. Parker, the defendant, acknowledging that she knew that JT might possess a firearm. And even if you find there was an assumed duty to Ms. Zwerner by Dr. Parker, you have to find that she was grossly negligent. What's gross negligence? I love this definition. It's the absence of slight diligence or the want of even scant care. And you might ask yourself, what does that mean? It's indifference. Indifference. And the evidence in this case doesn't show indifference. Mr. Beniozen glossed over the evidence, but bear with me because we're going to walk through it. And indifference is not inadequacy. So what happened on January 6, 2023 at Richneck Elementary School? We'll start the day where it starts. The first person to receive communication about a potential firearm, Amy Kovac. Who was Amy Kovac? She was the reading specialist, 33 years of teaching experience, third on the chain of command in the crisis plan at Richneck Elementary School, worked with JT every day. So on January 6, 2023, Dr. Parker was working with Amy Kovac on winter growth assessment testing. That's state standardized testing. There's specific rules that govern it. They were working together all day. Ms. Kovac told you she saw JT coming from lunch. He was happy, and he ran up to her and gave her a hug. She told JT, make good choices and make her proud. Then the two little girls came out of Ms. Werner's room to the doorway and told her that JT had a gun in his bag. Ms. Kovac went straight into Ms. Werner's room, straight to JT, and told him what the little girl said. And she asked JT, can I have that bag? He said no. So she sat with JT for a while and asked him, do you have a gun in the bag? He said, no one's getting the bag. And she said, okay. She stayed in the classroom for 30 minutes. 30 minutes. And made the decision to leave. She knew the child. What did she not do? Didn't follow up with the two little girls. Did not remove the backpack from the room. Did not remove JT from the room. Did not take JT down to administration. Did not evacuate the classroom. Did not call the guidance counselor. Made a plan to check the backpack when they went to recess. Went back to testing and had discussions with Dr. Parker. So this is the knowledge that gets sent to Dr. Parker. Now here's the part where you've got to decide which Amy Kovac to believe. The Amy Kovac that told Dr. Parker it was a toy gun, or the Amy Kovac that told Dr. Parker it was a real gun. But her actions don't suggest she thought it was a real gun, do they? Which Amy Kovac? She testified in front of you. Her personal thought was it was a toy gun, and she had told that to HR shortly after the incident. But then she testified in front of you. She told Dr. Parker that the girls had reported to her that there was a possible gun. Which Amy Kovac to believe? Try this one. Amy Kovac's text to Dr. Parker 2 days after the incident. Look at this. Amy Kovac to Dr. Parker. You are an amazing person and educator. No one could have ever predicted this. We all did our best. We did what a true teacher will do in this situation. Be there for our children in school. As I look back, I should have sent JT out of the room with a note and a job to deliver it around the school. And I could have gotten that book bag, but I didn't. We can't look back. We can only move forward. I love you and I'm proud to work with you. But that Amy Kovac didn't come to trial. She sat here and she threw shade at Dr. Parker. She dissed her work and she threw shade, not this Amy Kovac. Remember that. Credibility. You'll get an instruction on credibility and you can use your common sense. You see the jury instruction? You're the judges of the facts, the credibility of the witness, and the weight of the evidence. Use your common sense in judging testimony. Think about this. Who was the second person that day to hear about whether JT might have a weapon? It was Miss Zwerner. She was in the classroom when this went on with Miss Kovac, 30, 40 minutes, whatever it was. She sat here and she agreed that discipline is the initial responsibility of the teacher. She had dealt with misbehavior. How she dealt with student concerns was to first talk with the student. She told you she had taken a student by the hand, had removed a student from the classroom, and that was JT just 2 days before. He had thrown her phone, broken her screen protector, and she took him by the hand and she took him out of the classroom and brought him over to Miss West's class across the hall. She also told you that she had a classroom phone to call the office or parents. And she had requested assistance from guidance before, had requested help on the walkie-talkie. Miss West across the hall had the walkie-talkie. And the same day that JT threw her phone, she went over with JT and had Miss West get on the walkie-talkie and call Mr. Rawls to come and get them. So she knew how to remove him from the classroom. She also knew how to evacuate the classroom if she sensed danger. And remember, showed her the text. It was a year before. Miss Zwerner herself tells her friend Rosalie List, another teacher at the school, that Q was at the office all day. I had to evacuate my room early for lunch. But on this day, she was in there when Miss Kovac was there, loudly talking to JT about whether he had a gun in the backpack. She also told you in court that she had emailed Dr. Parker before. She had walked in and talked with Dr. Parker before. She had had guidance take students to Dr. Parker's office. Remember that testimony? You'd go to Dr. Parker at times. You would email her. You'd walk in her office. And if necessary, you'd get guidance to take the student to Dr. Parker's office. Ms. Zwerner told you that she had discussions with Dr. Parker about JT's behavior during lunch, but not about a report of the gun. She had discussion with Amy Kovac in her classroom about the reports from the two little girls in her classroom. She had discussion with Amy Kovac in her classroom after Amy spent time with JT and did not search the backpack. She witnessed JT rummaging through the backpack. She witnessed JT put something in his pocket. And she observed JT at recess with hands in his pockets and R telling JT to keep his hands in his pockets. She had discussion with Jennifer West about that, the lead teacher with the walkie-talkie, and discussion with Amy Kovac at recess. But there are things she did not do. She did not follow up with the two little girls. She did not speak to JT, did not remove the backpack from the room, did not remove JT from the room, did not take JT down to administration, did not evacuate the classroom, did not call the guidance counselor, did not make use of the walkie-talkie, and did not call the parents of JT. Did not seek classroom coverage to personally discuss any of this with Dr. Ebony Parker. No visit, no call, no email. You'll get a jury instruction on contributory negligence. It is the failure to act as a reasonable person would have acted for her own safety under the circumstances of this case. Any negligence of Ms. Zwerner, which was a proximate cause of the accident, will bar her from recovering. Let's talk about other people involved that day. Jennifer West. You remember Ms. West? First grade teacher across the hall. She had the walkie. Classroom right across the hall from Ms. Zwerner's classroom. Was on the playground during recess with other first grade classes. Learned about JT on the playground and the discussions about him. I was informed that he took something from his backpack. I can't speak for sure if I was told it was a weapon. That's what she said in court. She left the playground to deal with another student. Asked Ms. Zwerner to take her class back in the building. Remember, you're the judges of credibility. If you thought you were leaving a child on a playground with a gun, why don't you shepherd your class and my class back in the building? Use your common sense. Miss West encountered Dr. Parker in the hall. And so they've come in and said Dr. Parker was indifferent. Dr. Parker was dealing with another student, Miss West's student, and she didn't say anything to her about JT. Use your common sense. There was discussion with R about what JT showed him on the playground. We've heard about that. And Miss West said, R told me he said that JT had a gun and he saw it in the bullet. And I said, well, what color? Trying to see if it was real or not. And he said it was bullet color. In trial, Miss West had one version of that story. She was asked, Miss West, you testified that when you arrived on the playground, you weren't told specifically whether or not JT had a gun. Answer, that's what my note I wrote down notes that night, and that's what my notes say. But in her deposition, she had to admit she said something different. Your testimony under oath at the deposition preceding the trial was that Ms. Zwerner had reported to you the child did in fact have a firearm. Well, that's what I said then, yes. You're the judges of the credibility of these witnesses. John Sims, music teacher, covering phones in the office. The most important thing he told you, Ms. West didn't call him. He called her about another student, and that's when she mentioned what R had said. Now let's get to Mr. Rawls. Remember Mr. Rawls? Who was he? He was a guidance counselor. He was a member of the threat assessment team. He was part of JT's student success plan, worked with him all the time. Very familiar with JT, and he told you he had some learning and some behavioral issues. JT had been taken to Dr. Parker's office on multiple occasions. And he, in fact, had been the one to take JT to the office 2 days prior when Ms. Zwerner asked him to. Mr. Ross told you about what happened on January 6th. He was working with Ms. West on her student that had eloped, that Dr. Parker was all involved in. So Dr. Parker, I think it's been said that she was sitting in there in her armchair. She wasn't sitting in her office on her armchair. She was working. She was dealing with other student needs. Ask yourself, does it make any sense that she would attend to that and blow off a gun in the school? Mr. Ross said, I stumbled on some information about JT. No one called me. He's coming down the hall dealing with Miss West's student, and she tells him that R said something about ammunition or bullets. So Mr. Rawls spoke with R, and he did not interpret it to be a threat. It was a 6-year-old. 6-year-olds say things. Mr. Rawls, ever heard anything about a gun? No. You heard something about bullets? Yes. So at the time, you did not feel the need to remove JT from Ms. Werner's classroom? No, I did not. Later that day, or a little while later, Mr. Rawls had a discussion with Dr. Parker about the other student and about ammunition or bullets, and the bag already had been checked. He learned that the book bag had been checked. And he discussed with Dr. Parker, checking the person. Dr. Parker looked at the clock and said, why don't we wait for his mother to arrive? And he said he understood because he was 6. And so think of the context that was going on at this point. He'd been allowed, Ms. Kovac had investigated. She felt comfortable leaving the room. She felt comfortable not taking the backpack. She was not a young teacher. She was very experienced. She worked with this child every day. She knew this child, and she felt comfortable leaving that room. So that's a context. And then Ms. Zwerner didn't remove him from the room. And Mr. Ross told you he understood because it was a 6-year-old. And he didn't feel the need to go around Dr. Parker. He didn't feel the need to do that. It's a 6-year-old. Later in the day, Mr. Ross had gone back to his office. There was a lockdown, and he was coming down the hall. And he ran into some custodians. He didn't know there had been a shooting. And one of them said, they got him. And he said, got who? He told you he didn't have any idea who they were talking about. It was like, oh, it's JT. I knew it. I knew it. He didn't say that. He had no idea. And Mr. Ross told you that he went to his office and cried. You'll see that in the statement that HR had Dr. Parker write after, a couple days after. People hadn't lawyered up at that point. Maybe some of her language wasn't the best, but she told the story. She told that she cried too. They told the truth. No one saw this coming. Now let's talk about the experts in the case. Largely, their expert agrees with Dr. Klinger. Let's talk about it. Ann Shufflebarker. But let's first say, who is she? She's retired from the Virginia Beach Public Schools. She's never been an expert before. She was introduced to the case through her sister-in-law, one of Ms. Werner's attorneys. She agreed that this was a rare event. She agreed that the assistant principal is not solely responsible for school safety, that it's a team approach. You remember the Q&A? You agree that it's unfair to judge someone's conduct with 20/20 hindsight vision? I can see that. And you agree that Dr. Parker, in evaluating information regarding a 6-year-old having a loaded gun at school, something that had never happened to her, she didn't know the outcome of the day, correct? She also agreed that school safety is a team approach. It's not just one person's job, and we'll get to that in a minute, because Dr. Klinger made that clear to you and how that would be a terrible idea for it to be just one person's job. She agreed that the teacher in the classroom is the first line responder about student behavior. She agreed that assistant principals must rely on other staff members and teachers in determining whether reports are credible. She agreed that searching a student is a judgment call based on a lot of factors. She also agreed that it's preferred that parents are present during body searches of little students. She also agreed Dr. Parker didn't refuse to search JT. She wanted to wait until his mother got there because the level of concern was not high. Mr. Rawls had said it wasn't a credible threat. He told you that. She agreed that age is a factor in determining whether to body search a 6-year-old. Age and a lot of other things are a factor, she told you. Sex of a student's a factor. She agreed that you want to handle the student with dignity and that there are legal rights to their privacy concerns in body searching children. Most importantly, she told you she worked 40 years in the Virginia Beach public school system. And she told you that that never happened. No child, no elementary child ever brought a gun to school. Dr. Schuffelberger also agreed with me that Ms. Kovac and Ms. Zwerner were the first line responders to the reports about JT. She agreed that Ms. Kovac and Ms. Zwerner were in the classroom with JT after becoming aware of a potential weapon. She agreed that Ms. Kovac and Ms. Zwerner did not confiscate JT's backpack, and that they did not remove JT from the classroom, and that Mr. Rawls had not determined there to be a credible threat when he spoke to Dr. Parker about JT. She agreed that other individuals did not stop what they were doing. She said she should have stopped what she was doing, Dr. Parker, but she agreed that no one else did. And as you recall, she didn't know the facts of the case. She told you that it was two teachers that came and talked to Dr. Parker about body searching JT. And on cross, I had to get out the truth that it wasn't actually two teachers. She then acknowledged it. It was actually the guidance counselor on the threat assessment team who worked with the child every day. Surely, if he thought at that point there was a credible threat to search this child, he would have done something. You saw Mr. Rawls. Anybody doubt for a minute that he wouldn't take action if he felt like he needed to? Now let's move to the defense expert. You saw Amy Klinger, the defense expert. She has a Doctor of Education from the University of Toledo. She's a career educator and administrator. And now she works with school safety as a trainer and as a consultant. She founded the nonprofit called the Educator School Safety Network. She's a full tenured professor of educational administration. She's an instructor for FEMA and Homeland Security coursework. She has boots on the ground experience. She was a school principal from 1995 to 2008. She's researched, she's published, she's created training courses, and she's been an expert witness 25 times. Most of the time, she's against the school administrator. But she came here, and she wasn't against the school administrator. She wasn't against Dr. Parker. She told you that Dr. Parker did not breach professional standards with respect to Ms. Zwerner on January 6, 2023. And she told you that Dr. Parker, it was her opinion that Dr. Parker was not indifferent to Ms. Zwerner on January 6, 2023. She detailed how she came up with that opinion. She reviewed body-worn camera footage from the Sheriff's Department, including an interview with Ms. Kovac right after the incident. She reviewed the school board video interviews with people that were involved in the incident. She reviewed forensic interviews, witness statements, incident reports. She reviewed the protocols, and you're going to get an instruction about protocols. Protocols, you'll see, does not set the standard of care. But she reviewed them, and she told you that Dr. Parker didn't violate any protocols. She reviewed all the depositions taken in the case, and she reviewed JT's school records and his court records involving his mother. She reviewed all of that before she was willing to come and sit on the witness stand, swear to tell the truth, and give you her opinions in this case. Dr. Klinger told you that school safety is everyone's responsibility. It's a collaborative endeavor. School safety concerns do not occur in a vacuum. Every person in a school organization has roles and responsibilities related to school safety, every single person. A school administrator cannot establish the credibility of a potential threat alone. They cannot be everywhere, and they cannot see everything. She told you that it's important that the school administrator get information and disclosures from the people who are closest to the event. Dr. Klinger told you that discipline is the initial responsibility of a teacher. That's a standard nationwide. It's also in the Richneck Elementary School staff handbook that you've seen, and I think we'll go back to the jury room with you. Important to Dr. Klinger was the context of what else was going on and what Dr. Parker knew. That JT had been allowed to remain in the classroom and class instruction went on. The school day went on. The students went to recess. The first grade teacher discussed suspicious behavior on the playground, but they did not remove JT from the playground. Ms. Zwerner did not make any reports directly to Dr. Parker about a report that JT had a weapon. And she explained why that matters. She talked about first line responders. We've mentioned it before, I want to mention again. And what she said is when an administrator is evaluating a threat, it's important to know what sort of actions are being taken, so that what are the first line people doing regarding the credibility and the appropriate action to take for a response. And what she told you is that what really matters is plausibility and foreseeability. And she said when you're discussing a 6-year-old, it's much different conversation than if you're discussing a middle school or a high school student. This is a 6-year-old. And she told you that when discussing a 6-year-old having access and ability to bring a weapon to school, clearly, we know at this point, it's unprecedented. That means it hadn't happened before. It was largely unthinkable and certainly unprecedented. Your job is to consider only what Dr. Parker knew at the time. And Dr. Klinger wasn't the only one that told you it was unforeseeable and unprecedented. Dr. Shufflebarger. She agreed that in evaluating information regarding a 6-year-old having a loaded gun on January 6, 2023, it was something that had never happened, and that Dr. Parker would not have known the outcome of the day. Ms. Zwerner herself told you that when she saw the gun for the first time that day, when it was unfortunately pointed at her, that she was shocked because she didn't expect to see a real gun. And she had been in the classroom with this child and on the playground with this child. Amy Kovacs said it too. Who would believe that a 6-year-old would bring a gun to school premeditated to shoot his teacher? Mr. Rawls said it. He talked about hindsight bias and feeling regret about what happened. But let's look at what Corporal Blythe said. He was one of the first responders, the sheriff. What did he say? We were quite taken aback. We didn't expect to see such a young suspect. It was unforeseeable, it was unthinkable, and it was unprecedented. I submit to you that Dr. Parker did not assume a duty of care to Ms. Zwerner. She did not breach a duty of care, and that she was not grossly negligent. And it stops there. And you don't even get to damages. However, I need to talk to you a little bit about damages, and I'm going to tell you why. As you may recall, I questioned some of Ms. Zwerner's witnesses about her damages. And there was a reason I did that. Ms. Zwerner has come to this court asking for $40 million from Dr. Parker. And she told you that she cannot even open a bag of potato chips. And her counsel, he repeated that today. As an officer of the court, and as my ethical duty to Dr. Parker, it's my job, unpleasant as it is, to come in and tell you there's a different side to that story. I'm an officer of the court. And so I questioned Ms. Zwerner and some of her witnesses about the fact that she has gone to cosmetology school, passed with flying colors, and is a licensed cosmetologist. And some of her witnesses have come in and said she only wanted to be a teacher, but I've shown you, have admitted into evidence, are the texts that shows there's another side to that story too. And the other side to that story is that it was something, teaching was hard. And I'm not saying that to cast any blame on Ms. Zwerner, but to say she had thought about going to cosmetology school for years. So to come into the court and say, I only wanted to be a teacher, that's all I ever wanted, and now I can't, even though I don't think anyone testified she couldn't, I need $40 million. It's my job to tell you there's another side to that story. Ms. Zwerner and some of her family members have said that she can't leave her house, she's become reclusive, that she's withdrawn from the community. And again, I have to show you, when someone's asking $40 million from Dr. Parker, I have no choice but to say there's
Your Honor, the statement from Dr. Parker is an inappropriate statement of law.
Say that again?
The statement from Dr. Parker, I think, is contrary to the jury instruction.
I
They're
didn't
there to
make-
assess the damage.
I don't think she said anything that Dr. Parker said.
No,
I
I did not.
didn't hear that.
She stated from Dr. Parker, was counsel's argument.
All right, you overruled. You may proceed.
I showed you the social media posts that Ms. Zwerner produced in discovery. She produced them to us. Flip through them. She's reaching out to international celebrities to go to the concert 9 months after the shooting. Again, officer of the court, duty to my client, I have to tell you the other side. It's my job. And that's why we brought you Dr. Hagan. Dr. Hagan explained to you what a forensic evaluator does when determining whether someone has PTSD. Dr. Watson came, as eloquent as he was not Ms. Zwerner's treating healthcare provider. He was a retained expert, paid for by the plaintiff, to talk about her damages. But he did not look at her treatment records from before the shooting. He did not see that there had been diagnosis of PTSD before. And Ms. Zwerner herself, the last question she had to admit that she had not been truthful with Dr. Watson. I'm not minimizing what happened to Ms. Zwerner. I'm not doing that. I'm doing my job. I have to bring the truth and the whole story. It's the brutal honesty that Mr. Beniozen stood up when we selected this jury and told you he wanted. I have to do it. This case has been a long road for a lot of people. Mr. Beniozen glossed over the evidence in the case, and I want to thank you for listening to me as I went point by point what happened at Richneck Elementary School on January 6th. I went through the evidence, you heard the testimony, you weigh the credibility, these are the facts. And I would submit to you that when you go back and you consider the facts and the jury instructions that the court gave you, I would ask that you find that Dr. Parker did not assume a duty to Ms. Zwerner, she did not breach a duty to Ms. Zwerner, and she most certainly was not grossly negligent or indifferent to Ms. Zwerner. What happened at Richneck Elementary School on January 6, 2023 was a terrible tragedy on so many levels. So many levels. There's no one that does not think, that thinks otherwise. It was a tragedy that until that day was unprecedented, it was unthinkable, and it was unforeseeable. And I ask that you please not compound that tragedy by blaming Dr. Parker for it. Thank you.
Thank you. All right, you have a rebuttal closing, Mr. Beniozen?
Briefly, Your Honor. I get to go last. I'm going to be quick, I promise. Throughout the trial, every time somebody says something, that I am sitting there and I just want to jump out of my chair and scream and say, that's not right. That's not how it happened. I write note cards. I go at home, I write note cards, and I keep track of them. And I have note cards for every time that somebody said something and I just wanted to jump out of my chair. And I'm not going to go through all of them. I'm going to go through some of them, and I'm going to go through them quickly so that you can get back into that deliberation room, okay? All right. Testing day. Remember this? Testing day. Today was testing day. Ladies and gentlemen, if Dr. Parker took as much care for those tests and exercised that care for the safety and security of the children and the teachers at this school, we wouldn't be here today. Express promises to protect. Remember, they put up this thing and said, well, you didn't say anything to her. You didn't. Dr. Parker didn't expressly say to you, I'm going to protect you, and that Abby didn't tell Dr. Parker herself. Well, what happened to this collaborative team approach? What happened to this collaborative team approach that we're talking about? Is it not enough that as a team they talked and said Ms. Kovac is going to go tell her? Which one do you want? Do you want it to be a team, or do you want everything coming from the same person? You can't have it both ways. And they all worked as a team, each and every one of them, except for Dr. Parker. And Amy Kovac sends a text message 2 days after the fact. Amy Kovac was on that witness stand, and if you pull it up, go ahead and read the text message. Pull up the text message, Amy Kovac, on that witness stand. Did they ask Amy Kovac if, hey, did you know at that point in time that Dr. Parker was asked to search the boy at 1:40 p.m.? Did they ask him that? Did you know when you sent that text message that 2 other teachers came and asked her to search the person? Did they ask her that? Didn't want that answer. Did not want that answer. Because one person had all the puzzle pieces, and that person is Dr. Parker. And then you talk about going onto the playground. Going onto the playground. And what about what you did in the classroom? And why didn't you take him off the playground? And why didn't you search the backpack? The only reason they're able to point that finger of doubt at every single person in this school, except for Dr. Parker, is that Dr. Parker sat on her hands. At 12:21 p.m., if Dr. Parker was doing her job, she would have walked into that room, grabbed that book bag, and none of these questions would have ever been asked ever again. And because she didn't, because she sat on her hands, they now get to point the finger at every other person at this school and said, why didn't you pick up the ball that I dropped? Why didn't you pick up the ball that I dropped? And then they talk about what Mrs. Zwerner could have done sitting in that classroom. I want you to look at instruction 23 when you get in the back, okay? Instruction 23 says, a plaintiff has the right to assume, that a defendant will exercise ordinary care. until she realizes, or in the exercise of ordinary care, should realize that the defendant is not going to do so. What does that mean? That means that when Miss Zwerner talked to Miss Kovac, and they went and told the principal, who they knew it was her job to deal with a gun on campus, she had the right to assume that somebody was actually going to come into her classroom and do something about it. For every minute, she had the right to assume, whether it was in the classroom, on the playground, in the hallway, whatever, they had the right to assume that somebody was going to do their job and take care of her. And then they get up and say, oh, the expert's lying because she mixed up a guidance counselor with a teacher. But it's not just the expert that's lying. They're all lying. They're all lying. Ms. Kovac didn't tell you the truth. Ms. West didn't tell you the truth. Mr. Rawls, I think, sounds like they told you the truth a little bit. Ms. Zwerner didn't tell you the truth. Everyone's lying. Everyone's lying. What does that tell you about common sense? They had days of evidence where you got to go home on Friday. Not a single person called. It was their turn. The only people they called as an expert were the people that they paid to come into this courtroom, and you're telling us that we're the problem for paying people? If anybody supported your position, march them onto that witness stand and tell us all the materials that Dr. Klinger reviewed, all the materials you reviewed, a body camera, cops, witnesses. They help you? Put them on the witness stand. You didn't see a single one of them. You didn't see a single one of them. And if you didn't believe every word that was coming out of their mouth, and it's not exactly how it happened in your office, then get on the witness stand and tell us. There was all this conversation in jury voir dire about what it means to plead the Fifth Amendment. Ladies and gentlemen, somebody doesn't plead the Fifth Amendment unless they sit on that witness stand and say, I plead the Fifth. In a civil case, you don't have the right to remain silent until you actually exercise your right to remain silent. And not a single chance, they didn't want to take a single chance of her answering a single question. And if they didn't believe them...
Your Honor, I would object at the stage. I'd ask the sidebar, please.
No sidebar, overruled. You may
Then I
proceed.
would ask to voice my objection on the record, Your Honor.
You can after closing. Go ahead, Mr. Bayon.
And then we talk about Taylor Swift. Taylor Swift. What I want you to do is, if you watch that, if you look at that clip, I want you to read the second sentence. And the second sentence says, I am the first grade teacher that was shot by a 6-year-old. What does that mean to somebody? That your identity, I don't walk around saying I'm my mother's child. I'm a first grade teacher. And Miss Zwerner walks around life feeling like she has to tell everybody, this is me because this defines me. When you get into that jury room, the very last instruction is about life expectancy. What it says is that Ms. Zwerner has a life expectancy from today moving forward of 53 years. 53 years. Why is that instruction there for you? The instruction's there for you because when you're deciding what's full and what's fair, you're not just deciding tomorrow and what might happen the next day. You're not gassing up the plane to get to 45 or 55 years old. We don't get to come back here in 5, 10, 15 years and bring you all together and ask Ms. Zwerner, how are you doing? Are you still waking up at night? Do you still see that face? You have to make all of those decisions now. The other day, we took a lawyer break. Remember, the judge talked about lawyer breaks. A longer break than probably normal. And we were back in the room, and she was very nervous. And she was anxious. And we stood across the room from each other. And Ms. Toscano said to her, and I looked at her and I said, whatever burdens you have, put them on me. Whatever burden you're carrying, whether it's in your mind, your soul, your body, put it on me and let me carry it. Because that's what we do as lawyers. We accept to take this on through its ups and its downs, through the weight that it puts on our shoulders. And we accept that burden to be somebody's voice. And if I've talked more than I should, I'm sorry. If I haven't said the things that I should have said or how I should have said them, I'm sorry. I've done it the best that I can. The best that I can, and I love what I do. And if I could get in that room with you and scratch and claw and fight for her, do you doubt for a moment that I would? Do you doubt for a moment that she would or he would? I can't get in that room. This is the hardest part because now my burden's off and I pass it to you. And I say, fight for her. Fight for her, please, if you think it's what's right. And return a verdict in her favor that we've asked for. Thank you.
All right, thank you. Mr. Hogan, the court notes that your objection was made contemporaneously with the statement that was made. However, I'm going to further instruct the jury, and then after I release them, but before sending any instructions or evidence back, I'll hear your motion.
Thank you, Judge.
Okay.
Just to make sure for purposes of the record that I'm able to articulate my objection and seek the specific relief that I'm requesting.
Yeah, you'll be able to, I promise.
Before it is submitted to the jury.
I understand. That's what I'm doing, okay? All right. Members of the jury, this is an important case to both the plaintiff and the defendant. In order to reach a verdict, each of you must agree on that verdict. Your verdict must be unanimous in writing and signed by your foreperson. The first thing that you should do when you go back to the jury room is to select a presiding juror. Who is your foreperson? The role of the foreperson is to see to it that the deliberations are conducted in an orderly and businesslike manner, that they are conducted only in the jury room when all members of the jury are present, and that each juror has the opportunity to fully and fairly express his or her views. In the jury room, you will have access to the exhibits that were entered into evidence. You will have the instructions of law that I have read to you, and you will have the verdict form as well that I have explained. You should discuss the case with your fellow jurors to reach an agreement. If you can do so, I suggest that you discuss the evidence and the law to your satisfaction before taking a vote. If you find differences of opinion, and if it would be helpful to do so, I also suggest that you identify those issues as to which there are differences, and that you discuss to see if your differences can be resolved. Any comments made by the attorneys or the court during any objections or arguments are not evidence and should not be considered as such. Each of you must decide the case for yourself, but you should do so only after you have considered all the evidence and the law, discuss the case fully with your other jurors, and listen to the views of your fellow jurors. Don't be afraid to change your opinion if the discussion persuades you that you should, but do not come to a decision simply because other jurors think it is right. Each of you must make your own conscientious decision. Do not change an honest belief about the weight and effect of the evidence simply to reach a verdict. Your verdict must be based solely on the evidence and on the laws I have instructed you. Nothing I have said or done is intended to suggest what your verdict should be. That is entirely up for you to decide. As I told you at the beginning of this trial, there are two of you are alternates. We did not pick those prior to or during this trial. We are going to pick them now, and they are going to be randomly chosen. My clerk has put all 9 of your names into a container that no one can see the names of, and a neutral and individual who I've selected to be the court reporter who will not look at when he's picking, and he will pick 2 names out of those. After those names are picked, we will read you, they'll be given to me, and I'll tell you the numbers, which is why I asked you to bring your numbers with you now. You will then exit to the left with my bailiff, and you can retrieve anything from the jury room. So I have some good news for you, I think, for those of you who are alternates, that your term is over Friday. So you do not need to call back for any other potential jury service. However, since your term does extend through Friday, I ask that you do not discuss any of the jury service you have provided at any time during your month of service until after your term has expired. You are still under subpoena by the court. All right, court reporter.
I have 2. One. All right. Just the one. Yes, sir.
All right, Madam Clerk, can you please read the numbers of the alternates and excuse them?
Juror number 5 and juror number 32.
All right, you are the alternates for this jury, and you are excused.
Please bring the book.
Wait for the deputy to come back. Has the plaintiff gathered all the exhibits that are going back from your side?
They're all correct. Yes, sir.
Okay, and has the defense as well?
Yes, Your Honor.
Okay. All right, so how we are going to proceed once the deputy comes back is that I'm going to ask that you not begin your deliberations in the back. There is a couple other things we need to take care of. But then once the deputy brings you the jury instructions, the verdict form, and all the exhibits that have been entered into evidence, that is your cue to begin your deliberations. So don't begin until you receive those things in the back.